Hey, friends. I'm Jeffrey Rickman, and this is Plain Spoken. I'm a global Methodist elder in northeastern Oklahoma, and I've been reporting for some time on the United Methodist Church. That's a tribe I came out of. In 2023, there was this crazy event in North Carolina, Wilmington, North Carolina. This little church, Fifth Avenue, showed up to what was supposed to be a run of the mill disaffiliation meeting with their superintendent, and the bishop was there and like two superintendents, and they were informed that the church had been closed 2 days prior. There wasn't going to be any conversation. There wasn't going to be anything except them getting out of the building. And then the locks were changed, and it looked like it was just over. But I didn't even know until recently that they were able to actually file against the conference. And then initially, the trial court said, nothing to see here. This is over. And they appealed it. And what do you know? The appeals court said, no, this was inappropriate. You need to answer for these charges. And this was a welcome development to a lot of local churches that have just felt really put upon by annual conferences that just, stomp them. I've interviewed one other lawyer about this named Lloyd Lunsford, who explained a little bit about ecclesiastical abstention law and how trusts work in American law and where some of the moving parts are around this. I am far from a legal expert, but a lot of people who follow Plain Spoken have found some of the interviews that I've done, some of the things that I've covered to be useful in just navigating these different issues, because there's a lot of different things to consider. And so whenever I learned that the lawyer representing Fifth Avenue was willing to actually conduct an interview with me, I reached out. And this is Gavin here, right? Gavin representing the law firm. Oh, heck, I've got it right here. Ward and Smith. And so are you the only attorney for the church, or is your whole firm going to bat for them?
Our entire firm has made an appearance on their behalf. I am at this point the one lawyer that signed on the pleadings, but moving forward on the appeal, we have a couple of other folks that are going to be assisting me with this matter as well.
That's excellent. And so you've been handling this all from the beginning since they filed, right?
Yes, correct, correct. I have. I actually changed law firms right before the appellate opinion came out. So I had been with a Coates and Bennett, a smaller law firm in Cary, and then I do need to thank them. They supported me in taking on this case through the trial court division and through the appeal. And then I moved over to Ward and Smith. And when I was in conversations with them about joining the firm, I said, I do have this case that has generated some publicity, some controversy, and it involves the Methodist Church. And I said, are y'all okay taking this on? And to their credit, and I am grateful to them and the firm leadership for saying, yes, we take on all kinds of disputes from all walks, all stripes, and that they were perfectly comfortable stepping in and taking up the flag for the good folks at Fifth Avenue United Methodist Church of Wilmington. So I'm grateful to them, and we have some good appellate specialists that are going to help me with this case as well.
Lawyers can, of course, say no to serving anyone who comes to them. Was there any particular reasoning why it was that you were willing to say yes to Fifth Avenue? Do you think that they have a particularly compelling case?
Yes, and one of the primary reasons was I just thought this was wrong. You see disputes and things every day as a litigator, and you can't take every case, you can't help everyone. But I met with these folks, I talked to them, and a couple of things struck me. Number one, as I just said, that this was just wrong. But number two, their reaction to what happened to them. And I'd like to digress slightly right here because no one has asked. We've talked about the case. Everyone talks about the wonderful things that lawyers and law firms do, but I'd like to talk about my clients just briefly, because that's
Yeah,
part of
do
the
it.
reason I took this case is these folks are just wonderful, wonderful people. And often it is when I see folks, litigation is hard. on individuals, whether it's a company that's involved or whether it's an individual suing another individual. Litigation on an interpersonal level is just, it weighs on people. It is not good for the soul. It is not good for people. And part of our job as counselors is to care not only for the legal outcome, but also to advise people and companies about their well-being. These folks have remained together. What has happened to Fifth Avenue? Well, I tell you what, they're still there. They get together weekly. They have Bible study. They have prayer. They are staying together. They have continued to do good work for others. They have recently taken up a donation for the Methodist orphanage. So I just want to recognize their patience, their grace, and their unwavering commitment to their cause, but also doing it in the right way, because it's hard when you have been wronged, sometimes to act graceful and humble and walk in a way that you would want in a normal context. But when something bad happens to you, when someone wrongs you, it is not always easy to be graceful and peaceful and nice to your neighbor. And I really have to commend my folks that they have really just, it's not been easy. And particularly while the appeal was pending, every couple of weeks when a new round of appeals would come out, I would say, just stay patient, just stay patient. We'll hear something in maybe in 2 more weeks. And so I can't say enough nice. My clients, when I met them, I thought their reaction to what happened to them was unique. I think they have leaned on each other. They have leaned on their faith. Sorry, this is a very lawyerly, long-winded way of answering your question, but I really thought there's been a number of things written about this case, but I wanted to make sure folks understood that the congregation of Fifth Avenue United Methodist Church in Wilmington is alive and well. They could have disbanded when they had their building taken away, but that they have come together, and I think it's only made them stronger. And they're looking forward to the day when they can get back in their church building and continue to worship as they once did. So my clients, their character, their willingness to move forward in the right way and to try to maintain themselves in a, I would say, very polite and neighborly way to folks that they feel like have wronged them were just, it really made an impression on me, in addition to the fact that they had suffered what I considered to be a fairly egregious wrong.
Similar situation. There's always going to be differences between any two churches and any two conferences. But in Oklahoma, we had a couple of cases actually go to the Supreme Court. No, only one went to the Supreme Court, but two were decided by a state judge, where it was self-evident to the judge that the conference had behaved immorally and unfairly and utilized neutral principles law, and we'll come to that here in a little bit, to decide in favor of local churches. And then that was reversed by the Supreme Court in Oklahoma, which I think was a mistake. But again, I'm not a legal expert. There are these cases going on in Texas with the Rio, Texas conference, Baltimore, Washington. There have been cases down in Florida, and there continues to be in Alabama. And of course, there's so many moving pieces here that nobody could be an expert on this, although some people try and speak to that. We need to speak of the particulars of this case because it's my understanding, and I'm not the only one, that there are probably still over 1,000 churches in America that want nothing to do with the United Methodist Church anymore. But they're trapped. Their understanding is that the denomination holds all their property and assets in trust and can actually use it to deprive them of it if they step out of line. And so there are many that are discontent, but they're not talking. They are not even thinking about litigation nor any other measures of simply trying to walk away and take their assets with them. There might be a lot of different strategies available, and we can speak to those broader things. But I've already done my best to kind of say the story as I remember what happened to them. But other pertinent factors are, I think they're on 4 lots, the total taxable worth being $2 million. That almost certainly factors in. The reasons why the conference cited they did cite the Book of Discipline, I want to say paragraph 2549, to declare exigent circumstances and close the property. They argued that they had poor attendance and they were trying to leave. So they're just going to kick them out of their building. And then the other thing I think I'm recalling is that when Fifth Avenue filed suit, there were 7 different charges against the conference. They were all dismissed by the trial court, and now the appellate court has answered that actually 6 of those need to be taken seriously. There's only one that they could dismiss involving the word estoppel, which I never understand. So as I recapitulate all those things, fill in the blanks. What are the things that leaders of other churches that want out or feel like they've been done wrong, what are the factors they need to be looking at? What salient things happened at Fifth Avenue that you think are helpful to point out?
Fifth Avenue's case, one of the unique factors here, a couple things. The disaffiliation provision and the fact that this was not a church that was looking to sort of take their toys and leave. They followed the procedure. The conference had come to them, and there was a speaker that said no. I think it may have been their district superintendent or someone else said no. We understand different churches are interested in the disaffiliation process. We would like for they actively pursued them to stay. They said, no, we don't want you to leave, but here's some information, please stay. After that meeting, they also about that time, they entertained a speaker who spoke about disaffiliation. They considered all sides, and then they decided to pursue disaffiliation. So they were following the process. They provided the conference notice. They gave the conference all the written materials and other information they wanted, and they were following the process laid out by paragraph 2553 in the Book of Discipline. And they confirmed with the conference that they had done everything they were supposed to. Their documents were all in, and they were told there would be a meeting scheduled about their disaffiliation request. So they thought, and they submitted written requests saying, okay, now let's get a vote. Because their leadership voted. The next thing was for the DS to call for a vote from the church. And they thought that's what was happening, and instead it was closed. So they were in the middle of the process, and the conference cut it off deliberately. And so that is unique in this case. Some churches have tried to leave and just challenge the trust clause, saying based upon our deeds, and we're just going to challenge whether the trust clause allows you to hold on to this or not, and they've just left. Fifth Avenue did not do that. They tried to follow the process and say, well, again, we'll pay whatever fees are required, and we're playing by your rules. And so this is somewhat unique. I'm not aware of any other forced closures using exigent circumstances when a church had followed the Book of Discipline and was trying to disaffiliate. So that's unique with this case. That needs to be clear. And so part of that, to me, we pursued a breach of contract theory, saying that the Book of Discipline, that portion of it could be analyzed under as a contract between the conference and the church. There is a court in Georgia. It never made it to the appellate court. There was a trial court decision, and they also recognized a breach of contract theory. And at this point, I need to give a shout out to David Gibbs with the National Center for Life and Liberty. He pointed this decision out to me, and provided guidance and additional thoughts when we were looking at bringing this case. So that's unique here, is that we applied a breach of contract theory to this case, because a lot of cases it's about it's a declaratory judgment asking for a ruling. Does this trust clause does it apply to this parcel of property, or a quiet title, or something along those lines? The breach of contract theory is kind of unique. And now that 2553 has sunset and it's gone away, that I don't think there's going to be too many more lawsuits involving 2553, since they would have already had to have been filed.
Let me say what I think I'm understanding you to be saying. because I'm not a lawyer.
Oh yeah.
What what I think I would. Okay, so in America we have freedom of religion. The That's protected in the court system by ecclesiastical abstention doctrine, which means that a court cannot rule on anything pertaining to doctrinal affairs of a denominational entity. But that doesn't apply when you can claim neutral principles. Whenever there's clear contractual language that doesn't at all involve doctrine, then the state can get involved just to render whether or not a plain meaning of a contract was violated. So when you say breach of contract, what I think you're talking about is in paragraph 2553, which was the temporary disaffiliation measure that sunsetted at the end of 2023. It said that every local church has a right to disaffiliate under certain provisions. Fifth Avenue had that right, but it was deprived of that right by the annual conference because they refused to acknowledge that right. Is that how they were in breach of contract? Or
Correct.
I
Correct. And
got it.
that's what, yes,
Okay.
exactly. And that's what's unique because normally when you have these cases would come up and the North Carolina Court of Appeals, the North Carolina appellate court system has recognized has that trial courts can hear church property disputes. This has been going on for decades. I'm a North Carolina licensed lawyer. I'm not going to attempt to speak to other states. And this is a very state by state issue. But our we've argued to the Court of Appeals that there have been, a number of other cases with different Protestant denominations where there is a dispute over between the denomination and an individual church about who owns the church property in many, many different contexts. And so that is typically how these disputes come up, is that a church wants to leave for whatever reason and either become independent or join another denomination or whatever. That's happened for decades in North Carolina. And those individual churches or the conference or the denomination, excuse me, could go to their local county courthouse and have the dispute over who owned the church property determined like anybody else by a judge and jury. And so that's really, if that is if you wanted me to sort of boil down what is the main significance of this case right now, because I don't want to get too far afield with the breach of contract idea. That's why we're unique. Otherwise, this is just a garden variety church property dispute. Who gets Fifth Avenue's buildings and property? And that has been litigated in a number of other denominations and a number of other contexts for decades. So the idea that a church is disputing who owns its property, that's something that generally folks in North Carolina can go and have it determined. That's generally, so when we went to the Court of Appeals, that's what we were trying to say, is that, look, for years, people have had these kinds of disputes over who owns the building, and they were able to go again to their county court and have a judge and jury determine, win or lose, whether they get to keep the church or whether it belongs to the denomination. But the key thing is that it's decided through the civil courts and not by whatever religious hierarchy that church belonged to, if that makes sense.
Yeah, I hear you saying you don't want to get in the weeds here, but I'm getting deja vu from the Oklahoma case, and I'm wondering if perhaps Fifth Avenue is not as unique as you think it is, because the case that the trial lawyers made in Oklahoma, they didn't do exactly the same thing. The conference got wind that these two larger churches were wanting to disaffiliate, and so they put in a series of roadblocks in front of them that made it so that even if they completed them, it would be after the sunset of 2553, which to my mind is the same concept, because you have a contract that's in effect, it's on a timeline, and then you keep that from being actualized. Is that something different, or is that also potentially breach of contract?
That, and again, I will do the lawyerly thing and say I'm not an Oklahoma lawyer. However, I did read that trial court decision and we relied on it heavily until your Supreme Court took it away. But the idea that yes, that the Book of Discipline would be a contract, and in most states, there is a principle that when you are in a contract with someone, you have a duty of good faith and fair dealing.
Hmm.
And this is just a general contract principle, and that one party, you can't do something to the other party to deprive them of a right under a contract. It's not necessarily a something you would say, oh, that's definitely that's a black and white breach of contract.
Hmm.
It's a duty of good faith and fair dealing. You can't do something that's unfair and deprives your other contracting party. So by putting up roadblocks, by slowing the process down enough so that 2553 sunsets and these two churches couldn't complete the process, yes, that would also be a breach of contract. So that is a similar idea, that the breaches were different, but the principle of contract, it would be the same. Yes, that, 20 the disaffiliation provision in 2553, once offered to local churches, then the conference should play by the rules and not do things to make it more difficult or deprive someone of their ability to disaffiliate. So
So,
yes, it would be the same.
ooh, you came down more clearly than I thought you would at the end. The Okay, so here's another thing that was super common throughout lots of annual conferences. You're aware that 2553 stipulated a certain payout if they were going to get free, usually at least 2 years of apportionments, but also additional things that could be added on. One of the things that was seen in many annual conferences is that conferences anticipated local churches wanting that number and then giving them an inflated number so that they essentially intimidated a lot of local churches out of even engaging in the process to begin with. Is there anything attached to the concepts that we were just if they provided information that was not entirely accurate in order to dissuade local churches from even entertaining the process, could a local church be within a sane world coming back and saying, hey, you were unfaithful in contract and we need to revisit this? Or is that too much of a stretch?
Again, I'll do the lawyerly
Yeah,
thing, and
please
I will
do.
say
Yeah, that's why I'm.
it would, yes, it would be a case by case basis, but and it would be depend heavily on that state's law and the individual circumstances of the case. But yes, if they could say that potentially this was a breach of good faith and fair dealing in the contract, also they may have a claim for fraud, and is fraud is not barred by the First Amendment and the ecclesiastical abstention doctrine. So now again, fraud claims are difficult, and there you have to have a lot of very specific facts, and they're challenging in and of their own right. But in terms of if you're talking about a local church being able to get into court and stay in court and have its claim actually heard by judge and jury, then I think that they could potentially, yes, bring a plausible claim, depending on their individual facts. And again, one of the things you touched on this earlier is the ecclesiastical abstention doctrine is, there's stages of a lawsuit. So when you file a case, you file the complaint, and that lists out your facts and all of the claims you have. And then if you get after you file it, if the other side files an answer, you move into discovery, where you each ask each other for documents and answers to written questions, and you depose people asking them questions under oath. And then, but the initial phase, you can either a defendant can either answer, and you can go into discovery where they respond to the complaint, or they can file a motion to dismiss where they try to throw the complaint out and prevent you from getting into fact discovery. That's what happened to Fifth Avenue. We didn't even get off of go in monopoly terms. And the challenges they raised were the First Amendment, the ecclesiastical abstention doctrine, and that didn't even get to the merits of our claims. It was simply you can't even walk into the courthouse and file your claim because the court can't hear it. And that is a pretty big barrier right there. When you
Was
can't
that
even
weird?
get well, it was odd in this case because, again, North Carolina has been hearing church property disputes for decades and getting thrown out before we got past go. Yes,
That was
as the
weird. Okay.
person that was weird to me as someone that, told these good people that I thought they had valid claims. So, but again, then once you get past the ecclesiastical abstention doctrine, just says you can't even get past go.
Yeah.
But once you get past that, you get into fact discovery. You can ask for information from the other side. They can ask for it from you. And then there's summary judgment where they say, okay, now that all the facts have come in, do you have valid claims that you stated? And if you get past summary judgment, then you get to go to trial. So here, the ecclesiastical abstention doctrine is it's important again for religious institutions not to face challenges or be hauled into court over religious issues. I mean, I think everybody can agree that is important. But here, that it was an overstep in a church property dispute. And I understand why they made the claims and why they would assert this defense. But this is just one of the significant pieces of this case is that it should go forward. We should be allowed to get into discovery, and the court should be allowed to entertain the dispute, win or lose. We should at least get beyond go in monopoly terms. When North Carolina courts have been entertaining, again, church property disputes for decades. They've come out all kinds of different ways in the end, whether at summary judgment or at trial or settled somewhere along the way. But not to be allowed to get off go, that is to me the significance of what the Court of Appeals has said is Fifth Avenue, go ahead. You have, based upon what you've said, you have a church, you have a property dispute. Go on back to the courthouse and you can have it heard there. That's win or lose, you at least get to go past go. So that's really some of it is procedural in terms of the importance of it. Some of it is the other side will argue that it's a First Amendment issue, and they've indicated that they intend to take it to the North Carolina Supreme Court and argue that this is a key constitutional issue. And we intend to oppose it and say that again, this is your garden variety church property dispute that happens to have this fun little breach of contract issue as well.
So we should talk about discovery. I'm not sure how many churches know about, and I appreciate you walking us through the stages of a case, but discovery in other conferences has resulted in conference bishops and leadership having to send private email correspondence. Well, not private, but professional email correspondences, show text messages, pretty much anything in writing that has anything to do with conference business. Some have even inquired about specifics in accounting, the movement of money in the conference, and shown a lot of mismanagement of money in the conferences. So I'm curious about how much my understanding is now that the appellate court has said, no, it's a valid case. I think it has to come back to the trial court. Do you have the same judge or do you get a different judge?
We don't know at this point because North Carolina, we have a unique system where our Superior Court trial judges rotate. So they move around the state. So and it's a good system. But you just don't know because you don't necessarily have the same person every time. Our judges rotate, and it has worked for us for 100 years or so,
sure. Yeah.
More than 100 years. And it's, but so no, we may have the same judge. We had a judge that was from out of the county, rotate in and hold court for that term. So depending on when we get back to the trial court, we're not quite sure who may show up with a robe on, but they rotate. So we don't know.
So is there anything that can happen at this point that keeps you from filing for discovery, or is that the immediate next step once you go back?
We have already served discovery. That was one of the, yes, we filed the complaint and we sent out written discovery to the conference, the trustees. We sent subpoenas to a number of individuals, and also a document preservation letter where we politely but directly reminded them of their obligation to maintain those text messages and emails and to turn off all the auto delete features on their iPhone and things like that, because we do need those communications. So we've already asked for that information. When the trial court dismissed our case, there was also a request to stay discovery at that time. So the conference and all these individuals have our document requests and questions, and our request to, not get rid of any of that material. So they have it, and right now, the conference is seeking an appeal to the Supreme Court, and there is a potential that there may be a stay entered. So right now, we could potentially turn around and go back to the trial court and say we want our material now, but it's unclear at this time. Let's put it this way: once the appeal is resolved, there will definitely, if it's resolved in our favor, there will definitely be discovery, and the conference will ask us, no doubt, for information. We will seek additional information from them. In particular, the communications about the decision-making process for the closure. Because I grew up Presbyterian, and we had a number of committees, and there was a decision-making was in group settings, and to have that many people that were involved in the closure decision speak rapidly and with unanimous voices that this ought to happen this quickly. It is unique that any kind of structure like that would move that fast with that much unanimity. So the circumstances are unusual. So I would say here we are going to be seeking information about that process, particularly text messages, emails, any kind of other communications about this in this very short period of time that this occurred. So that
you just spoke about the appeals process being resolved. For people like me, we read this recent decision and go, sounds like it's resolved. It's going back to the trial court. The assumption that I had was that the trial court would now allow everything to unfold and it would make a decision. And only at that point that a verdict was rendered could the annual conference ask the Supreme Court of the state to get involved. But what I think I understood you to say is right now they're asking the Supreme Court to get involved because they don't appreciate this appellate court decision, or they don't agree with it, and they want the Supreme Court to say, no, the original trial court was in order. This is now dismissed. Have I understood that correctly?
That's correct. They our worthy opponents respectfully disagree with the Court of Appeals decision and have indicated that they're going to pursue an appeal to the North Carolina Supreme Court. And that in order to get there, they have to state this has to raise a substantial constitutional question. And we're kind of getting to one of those areas where I cannot give away too much. I don't want to give away too much or preview too much. We disagree with that. Again, saying this is a garden variety church property dispute. So there will be some question as to whether the North Carolina Supreme Court hears this case or not, or whether it goes back to the trial court. So,
but if it goes back to the trial court, there's no way to avoid discovery at that point. You can ask for all these things and they have to provide them. Is there anything, if they share information that is incriminating or otherwise embarrassing, is there anything that keeps you or your clients from sharing that information more broadly?
Not generally. There would have to be some sort of protective order entered. In civil cases, a lot of times the parties will agree either by agreement or by court order. There will be a protective order that protects confidential, sensitive financial information. If you have two competing businesses that sue each other over a contract, and they ask each other for financial information about damages or other business practices and things, they'll designate their information confidential pursuant to a protective order because they don't want that out there. Here, I don't know what the grounds would be in terms of keeping something confidential because these are there's no commercially sensitive information here. This is not nothing that should embarrass anybody. This is, so we would have to discuss a protective order. And I don't believe there's one in place in the trial court. In fact, I'm pretty sure there isn't. So at this point, discovery would be open, and there would be no prohibitions in terms of either side sharing information. In this case, is not. Again, you had mentioned certain conferences that there's discovery into financial information and things like that, and I don't know that we asked for anything like that. So I don't know that there would be any information that we've sought that would be sensitive that could, because the standard is usually, is it sensitive to the point it could harm the person producing it in terms of their business or profession. And so there really shouldn't be anything that would harm the conference in terms of their mission or business or profession.
Well, I know there have already been a number of cases litigated where embarrassing things about conferences were revealed, but then concealed afterwards so that they weren't for public consumption. Is it too late? Is the appeals or is the discovery process over, or could you solicit information about conference financials hypothetically if you were to determine that it was relevant?
Discovery is just, I'll go back to my monopoly analogy. We didn't get off go. And so now the parties could ask for any information they wanted in discovery. Again, the parties would ask for whatever they wanted here, and then the other side each party would be free to object and say, well, that's not relevant to the claims that are at issue here, that kind of thing. But we're just getting started. So yes, discovery.
Okay. It just seems with the $2 million property, it seems like there is a financial angle here. And my concern in asking that, I've been of the mind that a lot of these conferences maintain based on a false impression of who they are, their professionalism or capabilities as professionals, and that if people just saw what a lot of these conference officials said and did and how they handled or mishandled money or trust, that would cause them to crater. And so if that were to be seen more broadly, perhaps that would provide an incentive for them to play ball rather than do this posturing like they do. But you're the lawyer. I'm more about the Court of Public Appeals. I understand that a little, or not public appeal, of public I don't know what the word is I'm looking for. Opinion, public opinion.
Public opinion, yeah.
Yeah.
Public opinion is.
I think there are a lot of conferences that if people knew how they did business, would not get nearly as much in tithes and offerings, although that's fallen off anyway. We went way off to the side. There are 6 other charges so one was quite specific to this case that you're not thinking is going to be replicatable in many contexts, but there were a lot of other charges that you think could potentially stick and might be very interesting for other churches to look at. So can you speak to those?
Sure. And the first one I'll take off because this is the one I've been asked about the most. The one we didn't prevail on. People have said, now, wait a minute, you did get something thrown out. And yes, we did. We filed a claim for promissory estoppel. And that is typically in North Carolina has always been used as a defense. And there has not been neither our legislature nor a court has recognized it as an offensive claim that you could use to get something. And because we included it and argued for an extension of the law and asked the trial court and the Court of Appeals to recognize it for the first time as a offensive claim, and they declined. That we were very candidly in our brief said, court, this has never been recognized. And in the opinion, they said, yeah, you're right, Mr. Parsons. We haven't recognized it before, and it's not going to be today. So the promissory estoppel claim, we asked for an extension, and they declined in this case. But all of the other claims, the breach of contract, quiet title, judicial modification of trust, fraud, constructive fraud, were all dismissed at the trial court level based upon ecclesiastical abstention. The court said that you can't even get past go. You shouldn't even be here. You can't bring these things into court at all. And the Court of Appeals has now said, yes, you can. The court has jurisdiction to hear it.
I was reading the appellate court decision. I only made it about halfway through, but there was some case involving an African Methodist Episcopal Zion church where there was very explicit language of, look, just because it involves a church doesn't mean that we lose all faculties of discernment. I'm putting it in my own language, but that there is still a neutral principles way of determining whether or not these things took place. And so it's not like, oh, this involves a church and now there's a magic barrier up that we just can't touch. No, this has nothing to do with doctrine. So we can make a decision. So with these other charges that you just listed off, I didn't hear fraud in there though. Was fraud in there?
Oh no, there's fraud and constructive fraud. Yeah,
Excuse me.
absolutely.
Okay. So with all
Um,
of those, you can, from a neutral principles perspective, make the case as to why the annual conference is guilty of those things.
right. And I think I forgot, I left out declaratory judgment, which is
Okay.
asking the court to declare rights and obligations of parties. It is exactly what it says. So yeah, we have those claims. And they're all, again, we have a number of different claims, but it's all, the central idea is this is, again, a church property dispute. And is Fifth Avenue entitled to its property, or is does the trust clause operate to allow the conference to do whatever they want with it here? And we have a breach of contract. And so again, we're moving forward on all these claims with the exception of promissory estoppel, which again, that was a simple lawyerly request for an extension here, and they declined. So which was not a surprise. But all the rest of our claims are again, except for breach of contract, they're all grounded in decades worth of other Court of Appeals and North Carolina Supreme Court cases that have said, again, and I've said this probably a dozen times, win or lose, churches and denominations are entitled to go down to their county courthouse and have their differences settled over church property. And if it's the conference, or if it's the denomination, if it's the local church, who knows? But the key principle is the courthouse is open to both of them, and it will be decided by a judge and a jury, and not some other religious organization. So that's anybody else can go who has a property dispute can go to the New Hanover County Courthouse in Wilmington, North Carolina, and have their dispute heard by somebody in a robe and 12 of their peers. And that's all we were asking for our folks.
The anxiety a lot of churches carry, though, is we have decades of jurisprudence showing a clear preference for ecclesiastical authority on the denominational level, except in like Texas. In Texas, it seems to go the opposite way. But when we have all this jurisprudence showing that our judiciary leans in a certain direction, then is this just throwing money and at something that is hopeless? And so do you see there being room for hope that perhaps our judicial branch will start interpreting these decisions or these issues differently in favor of local churches?
Let me put it in context, because I talked about this before. Churches, if we're talking about Methodist churches at this point, I would say they're going to have to fight their way out. And I'm a counselor as well. This is a long, expensive, unpleasant process, and on a personal and emotional level. And so it's not just dollars and cents to us. It's also the people involved. We make sure that they are eyes wide open, soberly aware of how many miles they're going to have to slog through the snow. And it takes years of their lives, and in addition, a financial commitment. And so that's, again, when Warden Smith sits down with somebody and says, lawyers here say, you want us to go in and carry the torch for you. This is not just what it likely will cost, but there's also a human and emotional cost to it. And in particular, because it's a house of worship, folks generally have a deep emotional connection. And again, that's part of the reason I'm here is that my clients had a deep emotional connection to that wonderful building in Wilmington. Um, but in terms of our case, what would that do for other churches? I Again, it would depend on their state. Some states are more deferential to religious organizations than others. It would depend. And so again, ours also, the breach of contract does make it a little different. And if there is some other use of the book of discipline that turned out to be that could turn on a contract principle, that might be something that I would say that other folks in other areas might take a look at. Is that if they're, and again, it can't be something involving doctrine or qualifications of anything to do with your worship or tithing or any of that stuff. This is about sort of more mechanical type things. And so I think they would need to seek out somebody that's got experience in your Lloyd Lunsford. I've heard him speak on these topics, and someone like him or David Gibbs are have more context in terms of having seen this with a broader lens across different states and different areas of the country. It helps to have someone in with that kind of background that can compare, maybe one case to a dozen others. So I would say stay tuned. That again, we might get a helpful ruling moving forward also on the how our particular situation plays out with the trust clause. What is in our documents versus the trust clause? What happens with our breach of contract and fraud claims as well? So potentially our situation is unique, but depending on what the underlying facts are in other cases, someone may, by way of analogy, say, well, we don't have the same facts, but they were able to do this in this particular case based upon a contract and a fraud theory. Why not us? So it really just depends on the individual facts.
So what I hear
Here
you
too,
saying is there are some unique circumstances with Fifth Avenue that are uniquely advantageous for the church in making its case against the conference. When we're just talking about a normal church that had its chance to get out, either didn't file or filed and didn't make it through the process of 2553, there might not be a lot of hope right now, but there are a number of cases being pushed right now where, depending on what the decision is and rationale, there might be doors that could open up for churches to get out on down the line after these decisions are made. Did I hear a good spin on that?
yes, and I would say for folks that are in that category, I would look again. My friend in Florida, David Gibbs, I would look him up, and he is somebody that, or Lloyd Lunsford, that had through a lens of looking at a number of these cases over time. That would be a good place to start. If you do, we have what do we do? Do we have a case? What should we do?
Okay.
That's where I would start too, because I don't want to just say, yeah, maybe. I would say these are concrete steps they could take. Those are two people I would reach out to if I were in their situation.
So a lot of people are going to be watching you. There's Harvest Church down in Dothan, Alabama. There's some other places where there's some movement, but also different circumstances on the ground. What is it that people should be looking for in figuring out if this at all impacts their church that might be interested in getting out? What should they? Yeah, what kind of moving ground should they be looking at and going, "Ooh, that's interesting," or "That's promising," or "That's not promising at all"?
Again, I think the idea, if there are applications with the book of discipline that could be a breach of contract,
Mm.
that could be, you can interpret it based upon neutral principles. And I'm not coming up, and I apologize, I'm not coming up with a good example off
Yeah,
of
yeah,
my
yeah. That's
head,
fine. Yeah.
but I'm just thinking something that is, again, we're not talking about qualifications for ministry or how things happen in the church, but something more nuts and bolts, how churches are governed, things that make it, again, can be applied just you've said it, we've said it before, neutral principles of law. The idea that a breach of contract theory could be applied to this, again, as they say on network television, stay tuned. That might be one avenue. And so again, our our fraud claim, these kinds of things are very individualized. It's based upon individual facts. And again, like I've said, those are hard. You have to have a lot of they're hard to bring as as a lawyer. I think they're hard to bring, but they are. Fraud claims are not generally subject to ecclesiastical abstention.
Hmm.
So and again, I think our case fits that scenario. Other churches may have claims based on fraud. So it just depends on what interactions they have had with their, whether it's a Methodist conference, whether it's their other governing body. That's also a valid claim. It's just it's from a litigator's perspective, those are challenging to bring.
Feels the frustration for so many people is on the local church level. They're these people with consciences, and they just go, "This is so obviously wrong. It should just be so obvious and easy in a court of law." And then they learn about all these things, and they go, "Man, how frustrating! It's not obvious or easy at all." So, for better for worse, we need folks like you who can wade through these details and know how to swim through the waters. And it sounds like nothing is uh, set in stone, and a lot of things could happen, but it also sounds like you have a proper appreciation for the interpersonal and spiritual element here, and how taxing it is on congregations to uh, take on this endeavor. So, I from where I'm standing, and I haven't talked to but one person from Fifth Avenue, and it was very brief. I think it was before they even hired you on, maybe. But it sounds to me like they were blessed to find you, and that you're a good guy to have on board. So I hope that you and Gibbs and Lunsford and whoever else is a part of this helps us figure out the right way to go forward. And any closing thoughts for an audience that spent their time with us here?
No, thank you for having me. I appreciate you reaching out and giving me an opportunity to talk about my folks. I would say if to your audience, if there's anything they have heard today that resonates with them, moving forward, my folks could use your help. They could use your thoughts and prayers. They could use, if anyone decides they want to support them financially and is so moved, they could definitely use it. But just keep them in your thoughts. And again, I cannot commend my folks enough for their attitude. They're great. I feel like as a lawyer, I have learned something in this case, that I have
Mm.
seen folks react to a situation where they were wronged in a way that I'm blown away by the fact that by the way they have handled it, by the way they have carried themselves. If I were looking at my children saying, "Hey, when you're in a situation and you're trying to talk to someone and you're unhappy about something, you really need to emulate these folks at Fifth Avenue, because they have been, graceful, peaceful, and just have supported me and both of my law firms throughout every step of this process." So again, folks always look at the lawyers when you win and say, you guys are wonderful, and again, when we lose, you guys are not so wonderful. But the clients who are walking with you, who are carrying the weight of these matters, I just can't say enough good things about them. And to put something positive on what is it, you have disputes. I do try to focus on the positive at times, and one of the lessons I've taken out of this case is that they're just some amazing, amazing people.
High praise for the folks at Fifth Avenue. I hope they're pleased to watch the time you and I spent together. And friends, I hope that this is a blessing to you and your church. Of course, I would have loved to have found some kind of loophole here that just solves the thing for everybody, but unfortunately, like most things in life, it's a long, arduous slog. So remain faithful to the Lord first and foremost, and then be good to your brothers and sisters in your church. And I hope that this helps you in your discernment. Gavin, thank you so much for spending time with me and my audience. May God bless you and your clients. And yeah, we'll see what God has in store, huh?
Thank you so much. I appreciate the time.
Yes, sir. All right, friends, we'll see y'all later.